to give it a shape of mosque. All those evidences have also come in light in this ASI survey. Apart from that, the ASI has found in the so-called alleged Gyanvapi mosque various inscriptions written in various languages, Kannada, Tamil and other languages, which actually revere Lord Shiva, which actually are written by the devotees and which are originally a part of the structure. There are various artifacts. A teen number of artifacts have been found in this ASI survey, which proves to hint that this was the premise, this was the place of original Adi Visheshwar. The ASI has given a categorical finding that beneath the so-called structure, a huge structure, a pre-existing structure of Hindu temple is existing. The ASI has also given a finding that the existing structure, which is the disputed structure, is not a mosque. It is not having any characteristics of a mosque. So far as this controversy is concerned, that whether Gyanvapi mosque is a mosque or not, I think after reading the report of the ASI, this doubt can be cleared from the minds of all of us, because ASI is an expert body, and by virtue of section 45 of the Indian Evidence Act, it has an opinion it has the value of an expert opinion, and the experts have given an opinion that Gyanvapi mosque was existing on a pre-existing Hindu structure, and all the artifacts and all the evidences which have been found during the survey have been videographed, have been recorded by the ASI, and the report of the ASI was submitted before the Honorable Court on 25th of January 2024. Now there was an effort by Anjuman Intizamiya that when this ASI report was submitted, their entire planning was that this report should not be brought in the public domain. So it's my duty as a lawyer, because let me tell you that like in Ram Mandir case, all of us who are sitting here may not be parties to Ram Mandir case, but the judgment which was delivered by the Honorable Supreme Court as well as Honorable Allahabad High Court in Ram Mandir case is binding on all of us, because it was on the principle of Order 1 Rule 8. When the case is made as a case of Order 1 Rule 8, which means a representative suit, the legal principle is that even though the community, each and every individual of a community is not a party to the case, but whatever is the final verdict in that litigation, it is binding on both the communities. So that's why from that logic and from that perspective, Gyanvapi's case, Kashi Vishnath case, it's not just a case of Vishnu Shankar Jain or Hari Shankar Jain. This is a case of the entire community, and it was my duty to bring before the community what the ASI has said. And therefore, the moment the ASI report came, I read out the ASI report before all of you, and the ASI has given an important survey and opinion and expert evidence so far as the disputed area is concerned. Now coming to the other aspect as to what is remaining in Gyanvapi is a very crucial aspect. As you all know that survey exercise of Advocate Commissioner was carried out in Gyanvapi on 6th and 7th of May 2022 and 14th, 15th and 16th May 2022. On 16th May 2022, on the first floor of the so-called mosque, in the Wazu tank, we had found Shivlingam, and we believe, and I strongly believe, and I want to reiterate it before all of you, that Shivlingam is existing on the first floor, and it is going a lot deeper. And by no stretch of imagination, what we found on 16th May 2022 is a fountain. It's only a Shivlingam, Shivlingam and Shivlingam. Now, it's not that we just claimed it, that it's a Shivlingam and we kept mum. We immediately filed an application under Order 26 Rule 10A of the CPC, before the district court of Varanasi, and we asked that this area must be surveyed by the Archaeological Survey of India, and an expert report and expert opinion must be given that whether it's a Shivlingam or a fountain. The Honorable District Court of Varanasi had rejected our application on the ground that the Supreme Court has sealed these premises, therefore we cannot direct the ASI to enter into this sealed area. Though our interpretation was completely different, the Supreme Court on 20th of May 2022 had mentioned in its order that the district judge is at liberty to decide all the applications which are filed in this suit. So we challenge this order of the Honorable District Court of Varanasi before the Allahabad High Court, and Honorable Allahabad High Court, after hearing both the parties on 23rd of May 2023, on 12th of May 2023, had given a historical verdict, and the Honorable Allahabad High Court, after taking an affidavit from the ASI, which was running into 54 pages, where the ASI had also said that we can do this survey exercise of the Shivlingam area, of the Vazu tank area, without even damaging it, had directed on 12th of May 2023 to conduct this survey by the Archaeological Survey of India. Now, the irony is that Anjuman Intizamiya, which was saying that it is not a Shivlingam, it's a fountain, and they were so much ready with they were having so much of conviction in their argument, you will be surprised to know that the Anjuman Intizamiya approached the Honorable Supreme Court on 19th of May 2023, which was the last working day of the Supreme Court. After that, the Supreme Court was closing for summer vacations. And on 19th of May 2023, the Honorable Supreme Court stayed the order of the Honorable Allahabad High Court, which directed ASI survey in the Vazu tank area. So as of now, in Gyanvapi case, what remains is a very, very important and crucial piece of exercise that we need to have this survey conducted in this sealed area, and for that we have moved applications, and we are trying from past 1 year. We have moved application for vacation of the interim order. We have sought the Honorable Supreme Court to hear this matter, but as of now we are not successful, but I hope in future our voices will also be heard, and some day will come that when survey will be conducted in this sealed premises, and it will be proved to it that what we found on 16th May 2022 was a Shivlingam and was not a fountain. So that is one aspect of this entire case, Gyanvapi case. And after the ASI submitted a report, one very important development has happened, and I feel, and whatever I am narrating before you, I am really sorry, whatever I am narrating, please don't find that there is any emotion of what we have done. The emotion is, the idea is to tell you that what we can do as a community, and Gyanvapi case is a classic example that what we can do as a community, and for that I wanted to cite this very important development which has happened in this case. Let me tell you that during this entire ASI survey of 90 days which was conducted, a very shocking incident happened. Despite the orders of the Supreme Court and the Allahabad High Court, which directed the 4 women plaintiffs to participate in the ASI survey, those who argue that in Shabrimala women must enter, despite the orders of the highest court, 4 women plaintiffs were not allowed to enter the mosque during this survey exercise. And it so happened that right in front of Nandi, the Nandi which is situated in the present temple, there is Vyas Taikhana, which is on the ground floor of the so-called alleged mosque. In this Vyas Taikhana, from time immemorial and approximately from past 600 years, the Vyas family, through succession, through hereditary pujariship, through hereditary shivaiship, was worshipping in the premises in question. And it so happened that in violation of the Places of Worship Act 1991, the Vyas family was thrown out from that Vyas Taikhana by the Mulayam Singh Yadav government in November-December 1992-1993. and the puja which was conducted by the Vyas family was stopped. And at that Taikhana, there were two locks which were put. One key was with the Vyas family and the other key was with the district magistrate. Now this entire premises, if you would have seen on the mainstream media, is barricaded by iron fencing. So when we went for this ASI survey, we found that this gate of this Taikhana has been broken. There is no gate in this Taikhana. And when our senior counsel from the Supreme Court, lady senior counsel from the Supreme Court entered that Vyas Taikhana, she was told that you cannot enter this Taikhana because this is part of the mosque premises. So we understood during the ASI survey itself that a very deep-rooted conspiracy is going on to capture this Vyas Taikhana. They were claiming that Vyas Taikhana and all the efforts were going on to take illegal possession of this Vyas Taikhana. With this perspective, we filed a civil suit on behalf of the Vyas family in the District Court of Varanasi. The Honorable District Court of Varanasi heard the matter, and a very historical chain of events have happened. The Honorable District Court of Varanasi on 17th of January 2024 directed the receiver, which is the District Magistrate of Varanasi, to take over the possession of this Vyas Taikhana, and in compliance of the orders of the Honorable District Court of Varanasi on 24th of January 2024, the District Magistrate of Varanasi had taken over the possession of that Taikhana. Then we had a second prayer in our application, and the second prayer was that in the Vyas Taikhana, through rituals and through time immemorial, Niyamit Puja, Ramayana Part and Rudra Abhishek and all these puja parts were going on, which were stalled in November, December 1992-1993. So that puja part must start. And after hearing both the parties, the Honorable District Judge of Varanasi on 31st of January 2024 directed that puja part must immediately start, and within 6 hours, the Uttar Pradesh government, the receiver, in compliance of the orders of the District Court of Varanasi, started the puja part in the Vyas Taikhana, and from that day till today, the puja part in that Vyas Taikhana is going on. So now I put a question to myself, that on the ground floor of the so-called mosque, if puja part is going on, and if we read the report of the ASI, what is the religious character of the Gyanvapi mosque? The religious character was of a Hindu temple. It is the original seat of Lord Adi Visheshwar, and till today it is having all the characteristics of a Hindu temple, of the original seat of Adi Visheshwar. So by no stretch of imagination, it's a mosque, and the persons who are entering there and offering namaz is in total violation of our Sanatan Hindu principles. So the next step is that we are proceeding in the trial of the suit, and I must very frankly admit in front of all of you that after this order, which was passed by the Honorable District Judge of Varanasi on 31st of January 2024, there has not been much progress in the suit. For the reason that for 3 months, because the Honorable District Judge of Varanasi retired on 31st of January 2024 after passing this order, and from that time for next 3-4 months there was no appointment of District Judge of Varanasi. Let me tell you that there was a mandate given in this very case by the Honorable Supreme Court that this case has to be tried by the District Judge of Varanasi. But for 3 to 4 months there was no appointment in the District of Varanasi of the District Judge. And then in June, the courts had closed for summer break, summer holidays, and from July onward, this case is posted mostly on every Saturday, and whenever we travel to the District Court of Varanasi on Saturdays, there is either a condolence or a strike, and the matter is not being heard before the Honorable District Court of Varanasi. So, as a lawyer, the situation in front of us is that our matter, which I believe is a very core civilizational issue, is not being heard from past 9 months. There is no progress in the case from past 9 months, despite so much of efforts before the District Court of Varanasi, and I have filed an application before the Honorable Supreme Court, and the demand is, the prayer is that all these matters pertaining to Gyanvapi must be transferred to the Allahabad High Court before 3-judge bench of the Allahabad High Court for original trial, like it was done in Ram Mandir case, because this is a case which goes to the core of our sentiments. This is a case because out of 12 Jyotirlings, let me tell you, 5 Jyotirlings are Swayambhu, and out of those 5 Swayambhu Jyotirlings, the very first Jyotirling is of Adi Visheshwar, situated in Kashi. So this is a case which goes to our mother of civilization, which is the creator of civilization, and for this case, so many constitutional and important issues are arising that it must be transferred to the Honorable Allahabad High Court in exercise of powers under Section 24 of the CPC. Because in Uttar Pradesh, unlike other states, if you have to file any civil suit, it has to go before Civil Judge Senior Division, then it goes before the District Court, then it goes before the High Court, and then the Supreme Court. So 4-tier system is there. Unlike other states, if you have a commercial dispute, you can directly file a civil suit before the High Court. So there is such a legal concept in Uttar Pradesh that you have to file a civil suit before the Civil Judge Senior Division. So we have cut down one layer when the Supreme Court transferred this matter to the District Judge Varanasi, and now we are asking for getting our suit transferred to the Honorable Allahabad High Court, and I am hopeful that in the near future the Honorable Supreme Court, considering the prayers which have been made and considering the sensitivities which are involved in the matter, will examine this issue that whether this Kashi Vishnath case must be transferred to the Honorable Allahabad High Court for original trial, just like in Ram Mandir case it was done. So that is the program, that is the scope where our Kashi Vishnath case is existing as of now. Now moving forward, in Krishna Janmabhoomi case, certain very important developments have happened. Because there is paucity of time, so I am not going into the historical background of Krishna Janmabhoomi case, because I had explained it on this very platform on the last occasion. So a very important development has happened in Krishna Janmabhoomi case, that the Honorable when this matter in Krishna Janmabhoomi case, let me tell you that overall 15 civil suits were filed before the Civil Court of Mathura, and this issue was arising that it was very difficult for the matter to be adjudicated and decided before the Honorable Civil Court of Mathura. So we made a prayer and a request before the Honorable Allahabad High Court, and the request was that just like Ram Mandir case, Krishna Janmabhoomi case must also be transferred to the Honorable Allahabad High Court for original trial. And on 26th of May 2023, all the civil suits pertaining to Krishna Janmabhoomi case, accepting my prayer, were transferred to the Allahabad High Court for original trial. The trial started before the Honorable Allahabad High Court from 18th of October 2023, and immediately we moved an application before the Honorable Allahabad High Court for survey of Shahi Idgah Masjid by Advocate Commissioner. Our prayer of survey of Shahi Idgah Masjid by Advocate Commissioner was allowed by the Honorable Allahabad High Court, and when this order was challenged before the Honorable Supreme Court, the Honorable Supreme Court stayed the order of survey passed by the Honorable Allahabad High Court. So as of now in Krishna Janmabhoomi case, so far as the survey exercise is concerned, because we have very categorically mentioned in our application that this Shahi Idgah Mosque is no mosque in the eyes of law, and the Karagan of Kans, where Lord Krishna was born, is still existing there. There are a lot of idols of Hindu deities which are existing on this spot. The structure itself has all the signs and symbols of Hindu temple, but this order was stayed by the Honorable Supreme Court, and the matter is being listed before the Honorable Supreme Court on 5th of November 2024 this year. So we are hopeful that we will be able to convince the Honorable Supreme Court to vacate this interim order, and this survey of Advocate Commissioner, which is a non-invasive survey, must be conducted in the premises in question. Now, when this entire issue was stayed before the Honorable Supreme Court, it's not that we just kept silent. An application was filed by Shahi Idgah Masjid, and the argument by Shahi Idgah Masjid in Krishna Janmabhoomi case was that this case does not deserve merit. This case must be nipped in the bud. It must be dismissed at the threshold, and by virtue of powers enshrined under Order 7 Rule 11, this case must be dismissed, and 5 laws were quoted by Shahi Idgah Masjid before the Honorable Allahabad High Court, and those 5 laws were that their argument was that this suit is barred by the Places of Worship Act 1991, this suit is barred by the Waqf Act 1995, this suit is barred by the Specific Relief Act 1963, this suit is barred by the Limitation Act 1963, and this suit is barred by Order 23 Rule 3 of the CPC. Now let me explain it to you in very simple terms. Their argument was that Places of Worship Act has a mandate that what is existing on 15th August 1947 must exist as it is, and there cannot be any suit or lawsuit which can be filed for restoration. Their second argument was that Shahi Idgah Masjid is a Waqf property, and therefore this entire matter must be transferred to the Waqf tribunal, and it cannot be adjudicated by the Allahabad High Court. Their third argument was that there has been no relief of possession by the devotees of the Shahi Idgah Masjid, where we believe the sthan of the deity is. So therefore this suit is barred by the provisions of Specific Relief Act. Their fourth argument was that since there is a lot of delay in filing the suit, because their argument was that the suit is barred by Limitation Act, we have not come within the period of 3 years before the Honorable Court, therefore the suit is barred by Limitation Act. And last argument was that since there is already a compromise which has happened on 12th of October 1968, therefore the suit is barred by the provisions of Order 23 Rule 3A of the CPC. I must very strongly, the matter was heard before the Honorable Allahabad High Court in Krishna Janmabhoomi case from February till the month of June 2024 for 4 months, and after detailed hearing, the Honorable Allahabad High Court has given a historical verdict whereon all those 5 accounts which I have cited